Okay, good morning. Calling Doe versus Alpena.
She's ready to go.
Public Schools, I know, I like it.
I'm coming in here tired and beaten up. I look at you and you're just ready to go.
Red Bull gives you wings, John.
I gained energy just looking at you.
Is she already at the podium?
She's at the podium. We are ready to move forward.
Energy, terror, it's all the same thing.
This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you keep track of that yourself, and you may begin right now.
Thank you very much. Good morning, I believe it still is, Your Honor. Stephanie Arndt here today on behalf of Appellant Jane Doe. I'm going to try to reserve 3 to 4 minutes. I guess we'll see how that goes. Today it is really my privilege to be able to argue for the civil rights of Jane Doe and Michigan's 1.5 million kindergarten through 12th grade students. While ultimately this decision will reach on into university, really we're here today about sexual harassment in Michigan's public schools. Today we ask this court to recognize that Jane Doe had the right to an education free of sexual harassment, to hold that educational institutions violate the Elliott Larson Civil Rights Act when they fail to implement prompt and appropriate remedial measures to prevent sexual harassment that they know is occurring within their school. Jane is asking the court to give her the same rights and same protections that are afforded to her parents and all working Michiganders in the workplace. Jane's right to an educational experience that is unencumbered by sexual torment is protected by the Act. We ask that you recognize this right, adopt plaintiff's analytical framework as set forth in our brief, and reverse the dismissal of this action so that the trier of fact can decide this case. With that, I waive the remaining portion of my free fire. This court has received multiple amici supporting Jane Doe's position.
Okay, so you waved. I'll bite.
Okay.
You know, I'm one that likes the actual words of the statute to try to understand what it means, but we have case law from Michigan that tells us we can look to Title VII for guidance when we apply our Civil Rights Act. Why should we not look, in this instance, as an educational discrimination claim, why should we not look at Title IX for some guidance?
Well, there's actually several reasons why the court should not look to Title IX. Title IX is, first of all, it's founded in the spending clause. It's a spending provision about, people who receive federal funds can't discriminate. So the purpose
I'll put the emphasis
is different.
on discriminate, not spending, but go ahead.
The Elliott Larson Civil Rights Act obviously is always, this court has always said, is to be broadly interpreted. It even says that in the preamble, basically, is to protect all civil rights. Then you have, if we want to get to the statute, the Title IX does not have a private cause of action that is specifically stated. It has been a judicially implied cause of action. Here, the Elliott Larson Civil Rights Act has a specifically stated right to a cause of action, and it has language in 2402 that says things like purpose or effect of substantially interfering, creating a hostile, intimidating, hostile, or offensive environment. That is a much different standard than the severe and pervasive standard that the federal courts have now adopted, as well as, let's not even talk about the deliberate indifference standard. That is a much higher burden, a much more difficult hurdle for plaintiffs to cross. You also, if you adopt the Title IX standard instead of the Elliott Larson Radke standard, you now you don't run the risk. The reality is children and students will have one standard and workers will have a different standard.
Okay, well, just go down that path. How does the school's responsibility for the actions of students compared to an employer's responsibility for the act of its employees?
I'm sorry.
Well, you're holding a school responsible for that of a student.
Yes.
Compare that to an employer being held responsible for the acts of the employees. Isn't there any difference there? Shouldn't an educational institution be less responsible than an employer? I mean, after all, the employer gets to pick who is working for them. Public schools really can't pick what students they want to take in.
Yeah.
Shouldn't there be a distinction here between the employer-employee relationship and a more lax standard for school-student relationships?
No, Your Honor, because Jane Doe is statutorily required to be in that school. When she is in that school, she actually
Well, I
has
think that's my
less
point.
liberties because she's locked in that building. The school is that's why the whole discussion arises of in locos parentis, because the school, in that point, there's no parents around, there's no one there to help her, and she is a child. An employer situation, they have, yes, they can pick their employees and they can do background checks and things like that. But in this situation, the school knew that this child had problematic sexual behaviors. So that's not an issue, because he had done it to another little girl before her, and then he had been kind of groping her and grooming her all along until this rather significant first sexual assault happened.
So what should the school administration have done that it did not do here?
With regard to this case, the school, the first time that Jane Doe came to the school and complained, and she said, I'm in the lunchroom, he's touching my face, he's touching my hair, he's touching my legs. They should have done something. They did absolutely nothing. There's no record of it even in his student discipline report. Her friends then complain. They don't do anything. Then we have the sexual assault that happens on the 10th. And all they do is they suspend him for 3 days, and then they tell his instructional aide, who is supposed to be with him every single second he is in that building for behavioral issues, they tell her, watch him better. There's no information at all in this record that they actually followed up on that they were checking on him. But I want to address really quick the point of suspension, because I'm looking in some of the other cases that have dealt with similar issues. Suspension, they always say, well, you suspended him, that's okay. Okay, we're talking about fourth graders here. I have a third grader. You tell them you get to spend an extra 2 days at home, it's a reward. It's not, there's no punitive, there's no redirection. Chambers tells us that in order to have prompt and appropriate remedies, we have to do something that prevents future harassment.
So what would that have been here? If suspension doesn't satisfy that, what could the school have done?
The suspension could have been done in combination with something else that actually got to the heart of it. There's behavioral assessments that could have been done. There's parent meetings that could have happened to actually figure out why this child is exhibiting repeatedly these behaviors and what steps the school can take to address the core of his behaviors, and also to support her as the victim of sexual harassment.
Would you still be here if just the first incident happened and the subsequent ones did not? Would you still be here arguing this, that they did not do enough with the first instance?
When you say first instance, are you talking about the groomings in the lunchroom, or are you talking about the first sexual assault
I'm just want to make
on
sure.
February 10th?
The February 10th one. If that one had taken place and the May 8th and then the one later did not take place, would you still be here?
If steps have been taken after the February 10th incident that,
No, assuming that the record remains the same, just get rid of the subsequent events,
May 8 and later?
May 8 and later. Just look at the February 10th one.
so just he's suspended and it stops, and there's nothing else that happens in the future, most likely I would not be here. I mean, there is the unremedied issues that happened earlier in the school year.
So it's possible that the response from the school district at the February 10th, after the February 10th event was satisfactory.
No, it's not satisfactory because he reoffended. And I would also.
But we don't know that until the next offense. I'm just trying to understand when you're outlining what the school should have done and what they didn't do. That's why I asked if you would still be here, and you said probably not. But the schools need to know exactly what they need to do. If suspension isn't enough and it needs to be more than that, they just wait until maybe another incident happens? Or do they follow a certain protocol? They know what that is.
The school, yes, I agree that the school needs to know what they need to do. The school needs to implement measures that follow the situation, basically. I mean, Chambers says it has to prevent future sexual harassment of the plaintiff. So, okay, let's say all we were gonna do is suspend him, and suspension, that's it. Okay, then when he comes back, the very first day he comes back, Your Honor, he gropes her face. So we know that suspension wasn't enough. And by then, this is his third suspension for this year. The very first day, they let him sit right next to her in reading circle, and he strokes her face, and she gets very upset. Of course she does. She reports it. They should have seen it because the aide is supposed to be watching him every second of the day, but she reports it, and he gets a verbal reprimand. It doesn't even make it into his student discipline file. So we actually know on the very first day he's back in the building that it didn't work. So now we have to do something else. And how does a verbal reprimand, how does that protect Jane Doe? It doesn't. And it doesn't do anything to prevent sexual harassment in the future. And
So
that's
you presented evidence of an expert of all these other things they could have done, some national expert, I'm sure she's fantastic. Is that the standard? Like some national expert outlining everything a district's supposed to do? I mean, it's sort of getting to Justice Clement's point. I realize in hindsight, looking back, we can look at everything collectively. The district obviously is reacting in the moment with what is the appropriate remedial action.
right, and I would say that we're not asking for perfection. I mean, I do a lot of tort work, so it's kind of like a reasonableness standard, but not really. I mean, we're asking you to take steps to protect the civil rights of this young girl. And Chambers tells us that that comes in the form of preventing future sexual harassment. Say you thought suspension was good enough, and this case happens, and on the 16th he does it again. You now know you have not prevented sexual harassment. So now you have to do something else. If that's a behavioral assessment, if that's bringing in the school district psychologist, if that's getting counseling for Jane Doe, if that's separating them in the classrooms and lunch and recess, whatever that may be, you then have to do something else. And if then what you do else, what that added thing is, if that now prevents sexual harassment, then you've accomplished the goal. And hopefully the child can go on in a free and reasonably safe educational environment, and that other student can exist. I mean, there's been kind of this insinuation in the briefing, and he may have come right out and said it, that somehow we're advocating that this child should have just been immediately expelled. And that's not the case at all. I mean, I don't even know that suspension is an age-appropriate response. What we're advocating for is the protection of Jane Doe, the recognition that her civil rights have been violated and that she is being sexually harassed, and that there's steps taken so that she can continue in her school into the future, and that she can continue.
Counsel, I want to just, before your time's up,
Yes.
I want to turn back to sort of in loco parentis, which is sort of your hook to get to student-on-student behavior here, your answer to respondeat superior and Radke, all that. Have any other states used that theory under their civil rights statute that you know of? To sort of expand coverage to school students?
I would indicate to the court that the National Women's Law amicus brief does an amazing job at the end, giving kind of a state-by-state analysis.
Yeah, I saw a lot of
everybody's
statutes.
doing.
Yeah.
Statutes, but also, who's using kind of what standard, the severe or pervasive, severe, and all kinds of different things. I can't tell the court that there's one specific thing. Can I make one really quick point, though, on that whole notion of respondent superior? Justice Bernstein always says in oral arguments when I watch them, it seems like let's make this simple. Let's keep this simple. Okay, 2402 says, an educational institution shall not. Cox, this court, Cox versus Flint Board of Hospital Managers, talks about how there's always kind of two claims. There's the direct, and then there's the vicarious. In a coworker situation, if you know sometimes, then there's the whole vicarious argument. Here, John Rowe started the harassment, absolutely. It is Alpena Public Schools and their lack of response that created the environment. So while I understand, responding at superior has kind of been used for this whole concept of notice and prompt and appropriate remedial action, I just want to make the point that it is Alpena Public Schools that caused the environment to be hostile because they didn't stop the harassment.
Counsel, if we were to adopt in loco parentis, I'm just trying to think of sort of the ramifications of that for schools. Obviously, there's lots of other statutes, so it's obviously a big ask for the court. It would be a pretty big sea change for the sort of landscape of Elliott Larson. Would you agree with that?
I don't think that it would be a tremendous sea change, and I don't think that there's anything in the school code that, they reference repeatedly. I mean, the school code actually talks about restorative practices, and there's nothing in the school code that says educational rules and regulations, have to trump the Civil Rights Act. I don't understand why the two of them can't coexist. When she is in that building, when he is in that building, it is in locos parentis. The school is there. The school is the one in charge of discipline. While they can call the parents and consult the parents, it is the school that is in charge of her civil rights and his civil rights.
Last question. How would immunity work in this? The presumably, typically schools are immune from claims, tort claims. So how would this work? Would they be able to raise an immunity defense?
No, Your Honor. This is not a tort claim. It's a Civil Rights Act claim. And I believe there's decisions that are cited in my brief that discuss the fact that the Civil Rights Act claims are not subjected to the Government Tort Liability Act. And so there are no immunities that are afforded to schools when they violate the civil rights of a child.
Okay, thank you.
Good morning, Your Honors, and may it please the Court. Dan Lobel on behalf of the defendant appellees. The Court has raised two questions, whether the plaintiff has stated a cause of action under ELCRA. We would answer no. And the reason being is that, as Justice Sara pointed out, the plain language of the statute defines an educational institution as school, departments, other related things, as well as agents of the school. And I think the crux of the issue here is that the student, Mr. Rowe, in this particular circumstance, cannot be considered an agent of the school. I understand that the Court of Appeals determined that schools stand in loco parentis to its students, but just because there's mere control doesn't mean that it meets the rest of the principles necessary to establish agency, which is essentially a delegation of some type of authority for John Rowe to act on behalf of the school. And I would say that none of those circumstances are present here. But even if the court recognizes that this in loco parentis standard does stand, I believe it conflicts with the inherent language of the statute, as well as Justice Welch pointed out, the immunity issue, which is not necessarily under the GTLA, but it's created through negligent supervision cases such as Devil Bus, where the legislature has essentially abrogated parental immunity to some respects, except for circumstances where that arise out of the care, custody, and control of the child, which I believe is what we're claiming here, that the schools are taking on that responsibility at least for a temporary period of time. To be clear, we don't have any disagreement that the plaintiff is protected by or contemplated as a protected person under the ELCRA, but the ELCRA was not designed to impose liability for schools for the acts of its non-agents. In the employment context, and I think this distinction is clear, but in the employment context, as Justice Zara said, the employees are selected, hired. In the school context, they're obviously mandated to go by statute. But even in that...
Counsel, it appeared that this was a consistent, perpetual issue that was taking place with these two students. Why didn't your client take any action to prevent what ultimately happened?
Well, Your Honor, after the first incident, February 10th of 2017, the school obviously investigated the incident to make sure that it actually occurred. John Rowe was interviewed by the principal. He was given a 3-day out-of-school suspension. The principal contacted John's parents. The school success worker, Ms. Gilder, contacted the plaintiff's mother. The plaintiff's mother also reported the incident to police, who investigated the incident. Police interviewed John along with his parents and instilled to him that it was necessary for him to keep his hands to himself. The school also asked the plaintiff's mother if she wanted to move her daughter to a different classroom, and she left that decision to her daughter, who decided to remain in the classroom. Ms. Truman, who was the aide for Mr. Rowe, who's a special education student, she was also redirected to keep a closer eye on John. As far as the May 2017 incident goes, 3 months later, John and the plaintiff are in class. There's another incident that occurs. The plaintiff reports the incident to the teacher, Ms. Becker. Ms. Becker takes the plaintiff to see Ms. Gildner again. Ms. Becker calls the plaintiff's mother to tell her what had happened. Ms. Gilder, Principal Cardwell, as well as the police again, interview all of the parties, their parents, as well as other students who may have witnessed the incident to determine what actually occurred. And eventually they determined, despite the age of the students, that this was sexual conduct. After that time, John was suspended for 8 days. And when he returned, he was moved to a different classroom, he was given a different lunch schedule, and he was advised to have no contact with the plaintiff. Shortly thereafter, the plaintiff's mother actually withdrew her from the school. So there's no incidents in 5th grade because they're, well, I shouldn't say because, but they're in different schools at that point in time. In 6th grade, before the year started, the plaintiff's mother actually met with the middle school assistant principal to discuss and determine some things that could be done in order to prevent any further issues. John's aide was directed to be with him at all times. They would have lockers in different ends of the building.
So is it your, I mean, because, and I appreciate this because this was all in the briefs, but like, is there anything that you feel that, is it your contention that the school did everything it could have in this situation?
Well, Your Honor, I don't posit to say that the school did everything that it could have, but when we look at what the discipline is and how the school takes prompt and appropriate remedial action, it's prompt and appropriate remedial action. It's not a perfection standard, and it's certainly not a premonition standard. So the school acts to discipline John progressively and appropriately based on, in this particular circumstance, he's a special education student, so there's additional considerations that they have to make for disciplining him. Maybe one of the distinctions that didn't come through clearly in the briefing is that the revised school code actually says that for students who are 6th grade and younger, a number of factors have to be considered, and that would be for all students, but a number of factors have to be considered, and the question of suspension or expulsion for more than 180 days, I believe it is, cannot occur until the student is over the age of 6th grade or above the 6th grade level. So when we look at the first incident, a 3-day suspension, the second incident, an 8-day suspension, the school is making progressive and appropriate measures to try and discipline John. Not to mention, the school or the police are visiting his house each of these times, and I don't know about you, but as a kid, I mean, if I saw the police, I was pretty scared, you know?
Right, so shouldn't that have required some more dramatic action then? I mean, like, they were still on the same bus, they were still interacting, I mean, this just kept going on and on.
Well, the bus incident, and, you know, the school acknowledges that this was simply a miscommunication. They were actually supposed to be on different bus routes, but the transportation department didn't get the memo, so to speak, and they were on the same bus that day. The school then investigated the incident immediately after, found that there was no misconduct that occurred, and this was after interviewing staff, the bus drivers, as well as several students. And a letter was sent to the plaintiff's mother after that time, telling her that there was no misconduct that was found. The bus schedules were separated again, and there was no other incidents in the 2019 or 2018-2019 year.
Counsel, I'd love to turn to, sort of back to in loco parentis.
Sure.
So Elliott Larson defines employer, obviously, as including an employer's agents. Elliott Larson also defines education institutions as including their agents. So we know they're sort of parallel, right? We then have hostile work environment claims, where they're not necessarily agents, right? You can be employee on employee harassment, and as long as an employer knows about it, it's really not rooted in agency. I know traditional discrimination is, but hostile work environment is something a little different. It's a little bit of a different beast, which our Radke decision talked about. So I'm trying to figure out, is that parallel? You know, I know your argument is they are not, but I feel like, because I was trying to dig into the statute too and rely on the statute, and I feel like it's not helping me very much because they are parallel in how they both rely on agents. And we know in the employment context, you can have a hostile work environment, and if you have knowledge, you have obligations once you have knowledge as an employer.
To clarify, Your Honor, are you talking about third parties in circumstances that would say non-employees? Where
Correct.
They are
Yeah.
creating a hostile condition of the employment that the
I mean, it could
employees
even be an
are-
employee. I mean, students are, I guess, yeah. I mean, yes, we could say third parties. We know an outside agent comes in or an outside party comes in, a vendor is harassing the receptionist or whatever.
But just to supplement, even an employee, they're not acting within the scope of the agency. Even if there's a relationship between the employer and employee with the harasser, they're not acting within the scope of the agency, so.
But they could have still a hostile work environment
Correct.
claim if that agent continues the conduct and the employer knows about it.
Correct, and I think that's why Title IX is the best suited to address these type of claims, because they've developed the standard. The plaintiff certainly would have had a viable, would have been able to make a Title IX claim in this particular case in which they employ the deliberate indifference standard. And I think that standard, if we're to talk about any changing of the Radke standard here for addressing educational claims, that is the most appropriate, not only because you're giving the school an opportunity to take prompt and appropriate remedial action, you're defining the conduct, which I would say certainly, for college-age students, it's a little bit easier recognizable to determine that their conduct is obviously sexual in nature, determining their intent behind it. But I think that's really hard when you look at 10 and 11-year-olds. I mean, to me, or to the reasonable person, I should say, when they look at the Title IX standard, you're looking at whether the conduct is objectively offensive, not to say the individuals who are involved, but also a reasonable person.
Can we turn back? You made sort of passing reference to if we were to adopt the in loco parentis doctrine in this context, then there's sort of parental immunity arguments. Could you expand upon that a little more?
If I remember correctly, there was a parental immunity at one point in time which was abrogated some time ago.
I know, I think there's some exceptions.
And two exceptions that arise out of the Devil Bus case, where a person, not necessarily a parent directly, but someone acting in loco parentis, say a grandmother, I believe it was declined in the situation of a foster parents, but a grandmother, where she was standing in loco parentis responsible for the care, custody, and control of the child, and they found that she was entitled to immunity under that exception. So I think in this case, you're creating an inherent conflict potentially with, say, the fact that state institutions or governmental institutions aren't immune under ELCRA normally. But now if we were to recognize in loco parentis, then you potentially have a conflict for immunity that quasi-parents might enjoy as acting in loco parentis.
Thank you.
But to the court's point, as far as the discipline that occurs here, had the school expelled John Rowe or done something that violated IDEA or his IEP, then they potentially subject themselves to a claim from John Rowe. So I think that in this particular circumstance, it's not to elevate the rights of a disabled student over the rights of, say, someone who has a claim under ELCRA, but it's to balance those rights. And I think that the difficulty here is the schools have to do that. They have to balance the rights of all their students because they're required to provide a free and appropriate public education. Finally, Your Honors, there was a case decided recently by the Eastern District, Malik versus Croswell, Lexington area schools, and that's case number 22 CV 11126, and that was decided on February 20th of this year. Judge Lawson authored that opinion, and I think his words maybe clarify this dispute for the court, hopefully bring some clarity to it. No student should be required to endure the abuse from their peers. The school has a problem on their hands, but they are not deliberately indifferent to it. I would also note that the court cites to this case as well because there was an ELCRA claim. These students in their formative years were not born with racial hatred and antagonism, but it appears that those lessons were learned at home, not at school. It is not the district's job to do the impossible, purge its school and the community of actionable harassment, which I think is essentially what we're doing here by saying, what could the school have done differently? And I would say that there's cases that were cited by the Eastern District which distinguish between, say, repeated verbal reprimands that either don't result in reducing the harm or either increase the harm. For instance, the Vance versus Spencer Public Schools case, which was a federal decision. But the court has to look at whether it's prompt and remedial. Here, there's progressive and appropriate discipline. In the Mallet case, they also implemented progressive and appropriate discipline. And I would say that there were, racial discrimination case, there were numerous incidents of racial issues that were happening to the student who was the plaintiff in that case. And the court found that the school was taking prompt and appropriate remedial action in addressing each student's conduct, assigning appropriate discipline, and appropriate discipline under the circumstances might have been an apology letter written from the student to the plaintiff in that case. So
I'm sorry, the case that you're referencing, that was a Title IX case or was it an Elliott Larson case?
it was a Title IX case as well as an Alcor case. And the Alcor portion of the opinion, the court also cites to this case. But they use the deliberate indifference standard because that's the racial discrimination standard versus the sexual harassment standard. But juxtapose those two concepts, and I think that perhaps provides a good analysis here, which is looking at the school's action, whether or not it's happening and whether or not it's doing anything. Of course, the schools wanted to remedy the issue, but to say...
Isn't deliberate indifference and the federal standard and gross negligence under the GTLA standard, I mean, isn't that too low of a bar for what schools should be doing to protect disabled students from a sexual assault? I mean, it's a policy question, and obviously plaintiffs' counsel is being creative and trying to find legal remedies, but this whole system we have seems insufficient to me, and particularly in light of the fact that if you're in a private school, they don't have those same defenses, so they have to provide a higher standard of care for the children that they're looking after. Isn't that the whole tension here? Whether those, I mean, we all expect the schools to be more than just not deliberately indifferent, right? Schools don't advertise, bring your children to us and we won't be deliberately indifferent to their needs, especially your disabled children who can't protect themselves and can't even describe what's happening to them, right? They're not even accurate recorders of what's going on.
Your Honor, I see that my time is up, but to address your question, the plaintiff in this case was not a special education student. She was a general education student. Her harasser, so to speak.
But this all applies in that setting as well, does it not?
So when we talk about more protection, I find it interesting, and maybe the court would as well, is that the Supreme Court, the United States Supreme Court, has recognized that the right to attend public education is not a fundamental right, whereas the right to fulfill a livelihood is a fundamental right. But in the same circumstances, employees who are adults, for the most part, are held to a high standard in their jobs, where they can be terminated at will, for instance, whereas in the school setting, the revised school code delegates some discretion and some factors for the school administrators to consider, so that when we're talking about children, we're not sending them to prison, and we're not expelling them and kicking them out right away. And the schools, who I think are in the best position to fashion appropriate discipline, can weigh these factors and determine, is an 8-day suspension required? Does he need to seek other supports throughout the school? How do we protect the plaintiff's interests? Well, we're going to offer her tutoring, transportation. I think that the balancing act is what is done, is, as this court has recognized, best reserved to the schools. I don't think the protections are inadequate, and I don't think that imposing a Title IX standard is too high of a burden. I think it gives everybody a chance to investigate, sort out all the facts, and determine what's appropriate. And then if it's not appropriate or the school's not doing something, I still believe that the court has enough case law in the Title IX sector to determine, as a matter of law, what is prompt and appropriate.
All right, thank you, counsel.
Thank you, Your Honor, and thank you all.
Thank you both. The case will be submitted.